All right, buckle up. Today's case is an absolute roller coaster. We've got Miss Harris, a convicted felon who's been through probation, treatment programs, even prison time, and yet she's back in front of the court asking for another chance. Her attorney paints a picture of tragedy, family deaths, addiction, and a young daughter with medical needs. But here's the catch. Judge isn't buying it. This courtroom drama spirals fast, from emotional pleas to a sentencing hammer that drops harder than anyone expected. And if you think that's shocking, wait until the second half, when another defendant's reckless choices push the judge to the edge of frustration. Stay with me, because this one gets intense.
Mr. Rojas, you may proceed with argument.
Thank you, Judge. In the updated PSI, the recommendation, the last recommendation from probation is safety continuum.
Go ahead, I'm sorry.
And certainly, Ms. Harris is willing to do that. However, she would ask the court to consider something else given her circumstances. She's, as stated in the PSI, she's heard things about the JCDI program. She would like to have a chance in the JCDI program. Certainly, she feels that the reason that she relapsed was because she had some things going on in her life. She had a couple of cousins back last year that got shot, and her dealing with that herself and seeing the way it affected her mother caused her to relapse. But the reason she's asking for JCDI rather than safety, Judge, she's got a young child, a young daughter who has some medical issues. Her mom has been taking care, Ms. Harris's mother has been taking care of the child while she's been in custody, and the mother is here, the grandmother's here this morning, and I've spoken with her, Judge. When Chastity is out and she's taking care of the child, the grandmother says that she takes care of the child and she's tremendous help to the grandmother taking care of the child. And the child is going to need some surgery coming up. And the grandmother is being overwhelmed right now with that surgery and the medical issues. And for the child and the grandmother, more than for Chastity, Judge, we're asking for you to consider continuing her probation and considering JCDI rather than Safe P, just so that she can get out and take care of her child. I think Chastity wants to address that with you as well, Judge.
So here's the thing, though, Ms. Harris, and it's a bit frustrating to me. I feel for your family that is helping take care of your child, but it's not on me if you're not there to do that. And so using that doesn't really go very well with me, because it's you that put yourself where you are. You've already been.
Did you catch that? The defense played the sympathy card. Family tragedy, sick child, overwhelmed grandmother. But the judge flips it right back. It's not on me if you're not there. That's a brutal but fair truth. The courtroom isn't about excuses, it's about accountability. Harris had probation revoked before, was caught with firearms while on probation, went through multiple treatment programs, and still relapsed. So the judge is asking the obvious. How many lifelines does one person get? If you were the judge, would you give her another chance? Or is it finally time to say enough is enough?
Successfully completed the moral recognition therapy. You've been through the transitional treatment caseload, and you've been to the Spinal Tap outpatient center. There's nothing else. You are making choices now that addiction, at some point, you have to take advantage of the substantial tools that you've been given. Ms. Malfino?
I agree with you. Also, it's concerning to me that in the update PSI, she denies that she has a drug problem when clearly that's a big issue. And I do feel sorry for the situation that she's in.
We're going to find, Ms. Harris, that again, you entered your pleas of true to counts 1 and 3, freely and voluntarily. I find those counts true. Also find count 2 true. Find sufficient evidence to find you guilty in each of your cases. And cause number 17-28222 finds you guilty of the 3rd-degree felony offense of possession of a firearm by a felon. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections.
And there it is, 6 years behind bars. Notice how calm the judge was reading it, almost routine, but make no mistake. this is the end of the line for Harris. She argued for probation to care for her daughter, but her track record of relapse and denial of having a drug problem sealed her fate. This is the system balancing compassion against public safety, and in this moment, safety wins. Now, here's a question for you. Is locking her up justice, or would true justice have been one more chance at rehabilitation?
So, Mr. Turner, you were just revoked back in October of 2021 and received a state jail sentence. Whose court was that in? Was that here?
Yes, ma'am.
So I know then for certain that I read to you those written admonishments about not possessing a firearm, right?
Yes, ma'am.
And you have a prior terroristic threat, you have a prior assault causing bodily injury, and you're walking around with some other young person with guns and shooting at random with hoodies on. I mean, then I've got 1, 2, 3, 4, 5, 6 in the last month and a half, 6 incident reports from the jail where you cannot follow the instructions.
Wow, this judge's patience is officially gone. Turner's history reads like a warning label: terroristic threat, assault, caught running around with guns, and even 6 disciplinary write-ups from jail. At this point, the judge doesn't mince words. The longer society is protected from him, the better. This is the turning point in the hearing. The courtroom shifts from tragic addiction to outright danger. And let's be real, when a judge says the running around with guns has got to stop, that's not a lecture. It's a verdict on character.
You haven't maybe one of the co-defendants that I
No,
did
not
something
that
on.
I'm
This
aware
is
of, Your
very
Honor.
familiar to me.
Unfortunately, it's a pretty common fact pattern. It's 4 people riding around the car at 12:30 in the morning. There's 3 guns in the car.
Yeah. Okay.
And I'll just so the court's aware, the driver, Mr. Joseph Matthews,
Mhm.
who was charged with felon possession of a firearm for the firearm that's in the glove box of the car.
Mhm.
He was on parole after taking a plea deal for the offense of tampering with evidence for his involvement in a homicide. Mr. Dorsey, who fought with the police once they discovered a firearm in his waistband, is also a multiple-time felon. And then Mr. Sam has been convicted out of Harris County as a felon, as well as being on probation out of this court, Your Honor. So there was 3 guns in the car with these 4 people driving around.
In a deferred probation motion to revoke a deferred probation, they're typically, you're entitled to a bond, but there is a provision that allows me not to. I think it's just based on the evidence, which is what I'll do. And if there's any other issues, we'll do it that way.
Judge Lewis, can I say so?
Probably shouldn't. Mr. Sam, I'm going to deny your attorney's motion to set a bond in cause number 22-41263. Based on the nature of the underlying offense that you're on probation for, which is a robbery, where you were allowed to plead to the lesser included in that case for a probation.
And just when you think this courtroom can't get any heavier, the judge denies bail outright. Why? Because Sam wasn't just caught with felons and 3 guns in a car at midnight. He was already on probation for a violent robbery. That's strike 3, and the judge knows it. This is where community safety takes center stage. Think about it. Would you feel safe knowing someone with that record could walk free on bond? The judge clearly didn't.
So the fact that you had that conviction and got the probation already was, anyway.
That was essentially, I'll just let the court know that he was being held, he had a hold for that case.
All kind of at
while
the
we
same
handled the
time.
robbery here, Your Honor. I think he was transported back to Harris County after he pled on this case.
And got convicted in that case.
I believe so, Your Honor. I believe it is a final conviction.
Okay. And so based on the nature of the underlying facts that are alleged in that new offense, the fact that it is alleged that you were in a vehicle with several other people with at least 3 guns, other ones that are on parole and convicted felons as well. Obviously, all of that's a violation of your probation. I think in the interest of the safety of our community, and based on all of the factors set forth in 17.15, I am going to deny that bail be set in this case. If you will get that other case fast tracked if possible, so that it can get go through the grand jury process. If something happens and that case is not indicted, then I will reconsider at that point. Mr. Rojas, I would allow you to file another motion and I would reconsider that. And then once that case goes through that process, if it is indicted, then I want to move as quickly as we can. If there's going to be a plea of not guilty in that case, and then it would probably be my desire to go forward on that motion first if we need to. All right, we'll take care of that the next court date. You can go back with the bailiff.
So let's break this all down. Ms. Harris asked for mercy, but years of probation violations left the judge no choice. 6 years in prison. Turner's reckless gun antics? Another 5 years. And Sam? No bond, because his track record speaks louder than any plea. This courtroom wasn't about emotional stories. It was about accountability and community safety. These rulings remind us that the justice system struggles between second chances and protecting the public. So, what do you think? Were these sentences too harsh or completely justified? Let us know in the comments. And if you found this breakdown eye-opening, hit that like button, share with a friend, and don't forget to subscribe for more jaw-dropping courtroom commentary.